Good day everyone, welcome back to the channel. This is the House of Law and I'm Attorney Al Jumrani. In today's video, we will look at bar questions on lease in the last 10 bar exams. Since the last bar was 2019, we will go back up to the bar exam of 2009. By the way, if you are new to the channel, I am Attorney Al Jumrani. I make videos on the law subjects, and law-related issues. Please check out my playlists and videos. I hope you learn from them, and if you do, I would appreciate a like, a subscribe, and a share. Thank you very much. So, let's go down memory lane and go back to the year 2009. In the bar exams of that year, there was only one question on lease, and the question goes like this. Jude owned a building which he had leased to several tenants. Without informing his tenants, Jude sold the building to Ildefonso. Thereafter, the latter notified all the tenants that he is now the new owner of the building. Ildefonso ordered the tenants to vacate the premises within 30 days from notice because he had other plans for the building. The tenants refused to vacate, insisting that they will only do so when the term of the lease shall have expired. Is Ildefonso bound to respect the lease contracts between Jude and his tenants? Explain your answer. So here are the important things to note in that question. First, the lease, although presumably obvious and public, it was not registered in the registry of property. Second, it is not stated if Ildefonso was aware of the lease. Third, when the leased building was sold, the leases were not yet expired. Now remember, lease is a contract that deprives the owner or lessor of the possession but not the ownership of the property. Next, the owner or lessor is not prohibited by law to sell the property even though it is leased by another. Next, under the Civil Code, to bind third persons, the lease contract must be registered in the Registry of Property. What else? A third person who is not personally aware of an unregistered lease is not bound by it. The owner or lessor's right to sell the leased property is only impaired or restricted by contract, such as a prohibition against the sale thereof or a right of first refusal in favor of the lessee or lessees. Now, the right of ownership includes the right of possession. Also note that under Article 19 of the Civil Code, every person must act with justice, give everyone his due, and observe honesty and good faith. So, what is the answer to the question? The answer is no. Ildefonso is not bound to respect the lease contracts between Jude and his tenants since he was not aware either actually or constructively of the said lease contracts. As the new owner of the property, Ildefonso is entitled to its possession. At any rate, the 30-day period given to the tenants is fair and reasonable. All right. Now, for 2010, unfortunately, there was no question on lease. So let's go to 2011. The question on lease in the 2011 bar exam was a multiple choice question, and it goes like this. The term of a 5-year lease contract between X the lessor and Y the lessee, where rents were paid from month to month, came to an end. Still, Y continued using the property with X's consent. In such a case, it is understood that they impliedly renewed the lease. A, from month to month under the same conditions as to the rest. B, under the same terms and conditions as before. C, under the same terms except the rent which they or the court must fix. D, for only a year with the rent raised by 10% pursuant to the rental control law. Okay, notes from the question. First, the lease contract had already expired. Next, the lessee continued to use the property with the lessor's consent. Also, the rent was paid from month to month. Now remember this. Implied new lease or tacita reconduction grants the lessee the right to continue staying in the property without entering into a new contract. Also, the term of the implied new lease will depend on the period corresponding to the mode or term of payment. The implied new lease extends only on or to the right to use and enjoy the property, but it does not revive the other terms and conditions of the contract. So what is the answer? The correct answer is letter A. All right. For 2012, sadly, there was no question on lease. Although lease was a choice in at least 2 MCQ questions, definitely lease was not the answer to those 2 questions. Okay, now to the 2013 bar exam. There was one question on lease and it goes like this. Arlene owns a row of apartment houses in Kamuning, Quezon City. She agreed to lease apartment number 1 to Janet for a period of 18 months at the rate of 10,000 pesos per month. The lease was not covered by any contract. Janet promptly gave Arlene 2 months deposit and 18 checks covering the rental payment for 18 months. This show of good faith prompted Arlene to promise Janet that should Arlene decide to sell the property, she would give Janet the right of first refusal. Question number 1, for letter X. Not long after Janet moved in, she received news that her application for a Master of Law scholarship at King's College in London had been approved. Since her acceptance of the scholarship entailed a transfer of residence, Janet asked Arlene to return the advance rental payment she made. Arlene refused, prompting Janet to file an action to recover the payments. Arlene filed a motion to dismiss, claiming that the lease on which the action is based is unenforceable. If you were the judge, would you grant Arlene's motion to dismiss? So the choices are, yes, I will grant the motion because the lease contract between Arlene and Janet was not in writing. Hence, Janet may not enforce any right arising from the same contract. B, I will not grant the motion because to allow Arlene to retain the advance payments would amount to unjust enrichment. C, I will grant the motion because the action for recovery is premature. Janet should first secure a judicial rescission of the contract of lease. Or D, no, I will not grant the motion because the cause of action does not seek to enforce any right under the contract of lease. So notes from the question. 1. The lease is for more than 1 year. Next, the lease was not written. Next, the lessee had given 2 months deposit and 18 checks covering the rental payment for 18 months. Also, the lessor gave the lessee a right of first refusal. Now remember this. Under Article 1403(2)(e), the Statute of Frauds, a lease for more than 1 year should be in writing to be enforceable. Next, the Statute of Frauds does not apply to executed or partially or partly executed contracts. So what is the answer? The answer is, there is a valid and enforceable contract. The lessee can also rescind the contract. By rescission, the parties must restitute to each other what they received. Hence, the correct answer is letter B. All right. Now, the year is 2014. We have 2 questions on lease in the bar exam that year. First question. Spouses Magtanggol managed and operated a gasoline station on a 1,000 square meter lot which they leased from Francisco Bigla Awa. The contract was for a period of 3 years. When the contract expired, Francisco asked the spouses to peacefully vacate the premises. The spouses ignored the demand and continued with the operation of the gasoline station. 1 month after, Francisco, with the aid of a group of armed men, caused the closure of the gasoline station by constructing fences around it. Was the act of Francisco and his men lawful? Why? Notes from the question. The lease had already expired. Also, the lessees ignored the demand to vacate. Third, the lessor enclosed the property without the consent of the lessee. Remember this, under Article 1673 Civil Code, a lessee may be ejected when the lease period has expired. Also, under Article 433 of the Civil Code, the owner must resort to judicial process for the recovery of the property. Also, the right of a lessor to extrajudicially repossess the leased property applies only when there is a stipulation to that effect in the lease contract. So, what is the answer? The answer is no, the act of Francisco and his men was not lawful. Spouses magtanggol were in prior actual possession. In the absence of a stipulation granting the lessor the right to repossess the property after the expiration of the lease, Francisco should first file an ejectment case against spouses magtanggol for him to recover possession of the property. Okay, now let's go to the second question on lease in that same bar exam. Isaac leased the apartment of Dorothea for 2 years. 6 months after, Isaac subleased a portion of the apartment due to financial difficulty. Is the sublease contract valid? The choices are yes, it is valid for as long as all the elements of a valid sublease contract are present. B, yes, it is valid if there is no express prohibition for subleasing in the lease contract. C, no, it is void if there is no written consent on the part of the lessor. D, no, it is void because of breach of the lease contract. So note the following from the question. Isaac was a lessee. Isaac subleased a portion of the leased premises. Remember, under Article 1650 of the Civil Code, when there is no express prohibition, the lessee may sublease the thing leased in whole or in part. So what is the answer? Well, the correct answer is letter B. Now, because there were 2 questions on lease in 2014, there were no questions on lease in the 2015 and 2016 bar exams. Too bad, because lease should be a staple of the civil law bar exam, just like sales. Anyway, maybe the examiner did not feel the subject. Okay, let's now check the 2017 bar exam. There were 2 questions on lease. Mukhang bumawi. Okay, let's look at the first question. Briefly explain whether the following contracts are valid, rescissible, unenforceable, or void. So for letter B, a contract of lease of the Philippine Sea entered by and between Mitoy and Elsa. Remember that contracts to be valid must have an object that is licit and within the commerce of man. The term within the commerce of man means it is capable of appropriation or being the subject of contracts between private individuals. So, what is the answer? The answer is the contract of lease is void because the Philippine Sea is not within the commerce of man. Okay. All right. Now, the next question on lease in that exam was true or false? Explain your answers. So, letter B, a lessee cannot bring a case for quieting of title respecting the property that he leases. Remember that a lessee is stopped to deny the title of his landlord or to assert a better title while he remains in possession of the leased premises and until he surrenders possession to the lessor. So what is the answer to this question? The answer is true. Okay, now it's 2018. Let's see. We have one question on lease. Simon owned a townhouse that he rented out to Shannon, a flight attendant with Soleil Philippine Airlines, or SPA. They had no written contract but merely agreed on a 3-year lease. Shannon had been using the townhouse as her base in Manila and had been paying rentals for more than a year when she accepted a better job offer from Sing Airlines. This meant that Singapore was going to be her new base, and so she decided, without informing Simon, to sublease the townhouse to Sylvia, an office clerk in SPA. So A, can Simon compel Shannon to reduce the lease agreement into writing? And B, does the sublease without Simon's knowledge and consent constitute a ground for terminating the lease? Okay, notes from the question. First, Simon is the lessor, Shannon is the lessee. Next, the period of the lease is 3 years. Also, the lease contract is not written. Also, Shannon subleased the property. Now remember this, Article 1358 of the Civil Code provides that contracts must be in a public instrument for purposes of convenience of the parties. Also, Article 1357 of the Civil Code provides that either party can demand the other to observe that form after the contract has been perfected. And under Article 1650 Civil Code, when there is no express prohibition, the lessee may sublease the thing leased in whole or in part. So what is the answer? For letter A, yes, Simon can compel Shannon to reduce the lease contract into writing and in a public instrument in conformity with Article 1357 and 1358 of the Civil Code. For letter B, the sublease by Shannon to Sylvia is not a ground to rescind the contract of lease. Under Article 1650 of the Civil Code, the lessee may sublease the property if there is no express prohibition against it. All right. And last is the 2019 bar exam, the last handwritten bar exam. Okay, because this year's bar exam will be computerized, so we will remember the 2019 bar exam as the last handwritten bar exam. Now, we had one question on lease in that bar exam, and it goes like this. Mr. A entered into a lease contract covering one of his commercial buildings with XYZ Company, a partnership composed of X, Y, and Z as lessee for use as an office space. Upon failure to receive the rental payments when they fell due, Mr. A immediately sought payment of the same from X, Y, and Z, asserting that the individual partners are solidarily liable together with the partnership for its debts. X, Y, and Z disagreed with Mr. A's contention, arguing further that in any event, rentals should not be paid up until Mr. X or Mr. A makes the necessary arrangements for the repair of the defective electrical wirings in the office that caused power outages and hence made it difficult, if not impossible, for them to conduct their usual business operations. Rule on the parties' respective arguments. Now, here are some notes from the question. First, Mr. A is the lessor, XYZ Company is a partnership, and it is the lessee. Next, XYZ Company failed to pay the rents, complaining that Mr. A did not make the necessary repairs on the electrical wirings. Remember this. One of the obligations of the lessor is to make all necessary repairs on the thing. Under Article 1658, the lessee may suspend payment of the rent in case the lessor fails to make the necessary repairs. So, what do you think is the answer? The answer is XYZ Company is correct. Mr. A is not entitled to the payment of the rent not until he complies with his obligation to make the necessary repairs on the building. All right, so that's the end of the video. This is answering bar questions on lease. If you enjoyed the video, please drop a like. Please subscribe if you haven't subscribed yet. And please click that notification bell so that you will be notified in case I upload a new video. So I'll see you in my next one. Laging tatandaan, isip ay buksan, alamin ang batas.